Okay, let's go ahead and get started. Welcome, everyone. My name is Camden Hutchison. I am the director of the Center for Business Law here at UBC, and it's my pleasure to introduce our two panelists. We originally planned to have three, but unfortunately, Professor Abdi Aidid had to cancel at the last minute due to a childcare emergency. So he's unable to make it today for very understandable reasons. So unfortunately, we won't benefit from his insights. He was going to give us the sort of the academic perspective on things, but we have two lawyers working in the AI space who are going to give us the practice perspective. And so I'm sure we have plenty of great things to talk about. Let me go ahead and introduce our two panelists for today. So I'll start off with Sam Ip. He is a partner at Osler. Sam is a member of the technology group that regularly works with artificial intelligence companies and organizations making use of artificial intelligence technologies. This includes helping clients understand evolving global standards and regulations, assessing potential risks and liabilities associated with this emerging technology, and identifying processes for integrating artificial intelligence risk management strategies into organizational activities. Our second panelist, Francis Langlois, is an associate at McCarthy Tétrault. He works on files involving privacy issues, management of big data, software as service agreements, as well as working on important commercial transactions. In 2019, he co-wrote the report, Responsible AI, a Global Policy Framework, published by the International Technology Law Association. He is also a contributing author for McCarthy Tétrault's chapter in the first edition of Artificial Intelligence Law Over Borders Comparative Guide 2022. So obviously, AI is something that is on the minds of everyone, both within the legal community and more broadly. And so I guess I will go sort of sit down at another microphone and get the camera switched up. But while I'm doing that, maybe I could ask the two of you to just maybe give sort of your kind of initial, maybe kind of broad statement to set the stage on kind of where are we in terms of AI deals and lawyers who are working in commercial and corporate transactions. And, you know, what do you think the really sort of big issues that law students need to be aware of in the space right now? And I guess I would say since there's only two of you, you guys can just sort of, you know, jockey it out between you. You don't need to have like formal turns or anything.
Yeah, no, I'm happy to kick things off. And so first, let me just say it's such a privilege to be here. And be it 1 or 5 or 10 students, I'd be happy to kind of be here. It feels like yesterday I was a law student sitting kind of exactly where you are. And so my practice is to work with a lot of tech companies that are AI companies and companies that make use of AI. And I will tell you, in the last 10 years of practicing law, I've never seen as transformative of a technology as AI. You go back 2 years ago, 3 years ago even, tech companies were dealing with traditional kind of AI, traditional IP issues, traditional contracting issues. And over the last 2 years, it's been such a radical transformation where we see every client of ours either themselves innovating or really leaning into the possibilities of AI. And so want to touch on that and some of what we'll talk about. And so the commercial aspects and the opportunities. The other piece is regulation. So over the past kind of 18 months, maybe even 20 months, I've been very involved with what was Bill C-27. And part 3 of Bill C-27, to those of you that are following, is was the AI and Data Act. And so that bill kind of died by the wayside with the Parliament being prorogued, but would have introduced the first kind of federal AI piece of legislation. And although that's been kind of shelved at the moment, a lot of lessons learned along the way from a regulation perspective. And so why is this important to kind of the students here? Well, I think you're entering into such an interesting time where no matter what you pursue, be it competition law, business corporate law, commercial law, or even data privacy, I don't know that you can run away from a world where AI is going to intersect and just run into your own interests kind of head on. And so all of those things, love to talk about it, but I will say this is a topic where I'm always approaching with a bit of a humility. And so just as happy to share what I know, I'd love to kind of learn alongside you in the discussions with Francis and, of course, Professor Camden. Over to you, Francis.
Well, thanks, Sam. And I'll sing on you and saying, and so that's a real privilege to be speaking to all of you today. And it's an honor to be speaking alongside Sam, and greetings from Montreal. I mean, I fully agree with you, what you said, Sam, and it's the transformative aspect of the technology, especially in the last 2 years, has been very impressive. And what I'll maybe try to bring is the perspective from having been interested in AI for quite a long time, to see the transition from the world before ChatGPT and after ChatGPT has really been fascinating. And I keep being amazed how much the space has grown since, because of that single piece of technology that has kind of sort of concentrated the attention on AI. That's really been fascinating. And before then, I would say the work I was doing in AI was fairly limited and concentrated on thought leadership and concentrating on doing some advice to certain clients that were really looking towards what Sam mentioned, the Artificial Intelligence and Data Act that was introduced in 2022, that were also looking to what people were doing in Europe with the EU AI Act, which I'm sure we'll discuss. But with the arrival of ChatGPT, what has been fascinating is that all sorts of businesses from all across every industries have started getting interested in AI. So having discussions with people from the manufacturing industry, from the transportation industry, from the healthcare industry. It's really a transversal and global and total technology that affects and is weaved into a bunch of different industries and technologies. So to see the broadening of that sphere has been really interesting, and as from a practice perspective, has really brought some very interesting work. For instance, we were approached and we had a mandate from a client in the food industry, for instance, that wanted to use augmented reality coupled with AI in order to do product testing and food testing faster, right? And what could we help from, for instance, from an IP perspective, from a privacy perspective, with those issues. So that's really been interesting. And I think, to echo what you said, Sam, you will really see those AI issues regardless of the industries you end up working in, whether you come in private practice, or you go in working for clients, or you're going to work for the government. There's going to be some AI flavor to a lot of things that you're going to do.
All right, great. That was an excellent introduction. So I now want to ask you my first substantive question, which is really more of a business question than a legal question. So over the past year, artificial intelligence has become a major driver of investment and acquisition activity. We're all familiar with major AI platforms such as ChatGPT. But what are other ways that companies are either monetizing AI directly or integrating AI into pre-existing business models? In other words, what is the emerging business value of AI?
So, Francis, I can start, and I'm sure you'll have kind of comments as well. And I do want to say, I'm looking at the room, and there's about 5 or 6 of you, and I know there's about 9 online. Love for this to be discussion, although we're kind of over Zoom here. But raise your hand, ask us questions, interrupt us. We'd be happy to kind of have the conversation. We wish we were there in person. So let me kind of start with this. This business question, to me, starts with why AI? What does AI bring that in the world pre-AI doesn't bring? And if I were to ask the clients that I work with, they would probably tell me that in the world of AI and machine learning, what AI is very, very good at is that you don't have to construct the rules. And so a lot of times when we're talking about AI, we really mean machine learning, the ability for computers to learn on its own. And so when you don't have to construct the rules, you start to be able to solve interesting business problems that weren't so solvable before. So even just think about how hard is it to construct a spam filter? It's not actually that easy to tell what's really spam and what's not spam. And so you port that over to business problems. Things like fraud detection, for example, to even kind of vision in a manufacturing line, what is a defect and what is not. To construct the rules is really difficult, but it's really, really by comparison, easier to show examples. And if I asked clients why it is, they would say, it's that. It's that I don't have to construct the rules, but I have lots of examples. And so how does it play out in the clients that I work with? Well, it's transformed them because they are now looking for opportunities to solve problems there. And they're doing one of a couple of things, usually. They are either tech companies that are building the backbone of their solution on an AI. And so what I mean by that is, in the old world, you'd have a whole bunch of programmers code the logic to things. Well, now they're shifting over to model builders, data scientists to build the logic of the solution in AI. You've got companies that maybe are not tech companies, but are companies that are more traditional. Maybe it's a software company. They're looking for opportunities to infuse AI features into their platform. And what are they typically? If you would ask me, it would be often it's client service always ranks at the top. Data analytics is the second. And third of all, you've got kind of organizations trying to make use of kind of AI technologies, which is more like your usage where you're kind of ChatGPT. All of this for the sake of really a couple of things, right? Increasing margins, decreasing costs, and improving kind of revenues. Before I pass it over to Francis, I want to leave you with one thing. If you're looking at kind of thinking about the business implications, and I'm glad Professor Camden started with that, because the reality is the practice of law really is about advising businesses with a legal lens. And so the one thing I would suggest and even recommend is there's a podcast, BG2 podcast, where Satya Nadella was interviewed. And they asked him the question, right? Satya Nadella is the CEO of Microsoft, who took the cloud business from 10 billion to I think 60 billion in revenues. And they asked him the question, what do you think is going to happen with SaaS? And he thinks SaaS is going to be dead. For a guy who built the SaaS business, it's a pretty remarkable statement. And he says that because of how transformative AI is and how in the year 2025, it will be the year of AI agents being able to do what, people like you and me can do. And so I'll pause there and I'll pass it over to Francis. But the short answer is in almost every way, in almost every sector, in a way that I have not seen in the last 10 years. So over to you as well, Francis.
How I would summarize this from what I've seen from client is with the word productivity. It's really interesting because I've worked on a massive commercial transaction most of last year, which involved a Canadian company improving and transforming how it does its application development internally. So software development, developing their software solutions, and how they go about developing their code base. And to do so, they contracted with a major consulting firm that, as part of their service offering, included AI technology, and we'll say it's basically saying, well, we're going to improve how you work and how we work using AI technology. And a big arguments they were bringing on the table is the productivity argument. So I think that's something that a lot of businesses are seeking when they're developing AI solution internally, or they dealing with service providers to procure AI solution. They want productivity, and in Canada in particular, this has a specific resonance in a context where we're trying to solve a long-standing productivity issue. And there's a lot of people in the market have hopes that AI is at least part of a solution in that equation. So bringing productivity, and from that file, another concept that was interesting is the concept of velocity, right? So AI allows us to do more, but it also allows us to do more faster. And I think from discussing with other clients, discussing with people in the space that develop AI solution, those are kind of like two important concepts that businesses are trying to get out of an AI. Do better, and do faster with technology that complement human beings. And in that file specifically, it was, for instance, coding assistants, right? And Sam, I'm sure you've seen those tools. For instance, one of the most famous ones is GitHub Copilot, right? Who help coders, write their code faster, bringing applications to production faster. And we're seeing that, at least I'm seeing that in multiple industries.
Yeah.
Yeah, go ahead.
Oh, no, go ahead.
Yeah, I was about just to kind of like continue with parallel with what we're seeing, and Sam, I'd be curious to hear what you're doing at Osler, but we're seeing that in our own practice, right? The introduction of new productivity tools around AI, whether it be to help us manage cases, conduct due diligence, organize matters. So it's not only something that's happening with our clients, but it's also something that we're seeing in our own practice. And when you guys are going to start practicing really soon, I think those tools will be even more prevalent. So starting to get used to these tools, learning how to use these tools, I think is a really useful skill that you can already start picking up.
Yeah. And Francis, just and of course, to keep it conversational, I see it too here at Osler as well. One of the clients that I advise is the Human Resources Professionals Organization. So they're an organization, like an industry kind of organization.
Right.
And we always have conversations about the impact of the workforce, and productivity is key. And so there's a lot of discussion about how the new world, it's no longer as much of a pyramid as much as now it is becoming more of a square, right? Where you don't need perhaps as much of the folks that are doing the work that can be distilled down to instructions. A lot of that work is being transformed and being taken over by potentially AI. So it's a very interesting kind of conversation. But the other also interesting part is, Francis, you talked about some of the GDP issues, GDP per capita issues, and a lot of the regulatory discussions for a lot of the folks in the audience that have a policy bent or have aspirations to kind of be involved with policy is really this GDP per capita issue, this productivity decline. Of the G7 countries, Canada does not fare very well. And compared to our American neighbors, not so well, right? In some cases, 40% less productive in certain provinces. And so how do you deal with that? It's about putting in place regulation, framework, support for Canadian businesses to be able to be more productive. And lawyers have a role in shaping policy, in being able to support and facilitate this while mitigating some of the related risks.
Very interesting. I guess I would maybe just respond with my own 2 cents. I'm not an expert on AI, but just sort of as an observer of the startup economy and as an observer of the economy more broadly. If you look at kind of the last 10 years, like sort of what the hype cycle has been, certainly in venture capital, it's like we were told, blockchain was going to change the world. We were told Web3 was going to change the world. We were told the metaverse was going to change the world. And I think a lot of that was hype, but I do feel like AI is the real deal. Like, I think it really is transformative in a way that prior hype cycles have not been. So there's just if you don't know, there's a tremendous amount of money being invested by venture capital firms and large corporates in AI. So it's certainly the leading kind of hype sector in startup investment right now. But I think it's real. Like, I think it really is going to transform the economy. So that kind of leads to a follow-up question, which is, what are the different types of companies within the AI value chain, and what are the different rationales for a buyer to acquire them? Or in other words, what are your clients' goals, either in investing in AI companies or as AI companies receiving outside investment?
Maybe I can start just quickly, Sam. So I think to discuss about the AI value chain, I think before talking about who's investing in there, I think it's a very important concept, the AI value chain, because from a legal perspective, that's a concept that is also included. So it's not just an industry concept, it's also a concept that you will find in the EU AI Act, in the US laws, especially at the state level. And there's different ways you can present the AI value chain, but usually you have different players that have different roles in the pipeline that leads to the creation of an AI product at the end of the day, right? And usually you will start by some providers of AI raw materials, right? So that could be AI data, the AI knowledge. And sometimes those actors are willing participants, so they will provide data. And sometimes there are, participants that don't even know that they're participating in the process, as we've seen in the process of scraping the web that has led to the creation of, the large language model, right? So a lot of the people that have, that now find their data in those data sets, well, we're not aware that that kind of scraping was taking place, and we're seeing lawsuits right now in the U.S. but also in Canada to determine whether or not that scraping was lawful based on intellectual property laws. So that's kind of like a first layers. But then you have usually the bigger names in AI, so the AI developers. And then you have the big large language model providers like OpenAI, Mistral. In Canada, we have Cohere. And then the EU AI Act in particular has also a definition of AI deployers that are not necessarily the AI developers per se, but are the players that maybe buy an AI system that has been produced by an AI developers, and then they bring in on the market, right? And so you can have different companies that don't necessarily develop the AI system. So if you can, for instance, think about a bank, for instance, that use a third party large language model into a chatbot that it now deploys on its website to interact with customers. And then finally, you have users, and users, they can be you and I when you go on and use ChatGPT or other AI systems. But also companies, right, that don't necessarily deploy the system externally, but they use them internally, right? For instance, the companies that use the Copilot system from Microsoft, for instance. And so you have all those different players. And if you want to have an idea of the structure of the and how regulators are thinking about that structure in Canada, the Competition Bureau in Canada has recently published its report on artificial intelligence and competition law, and they have a really interesting discussion between about the different players in the AI value chain and how they are seeing it play out in Canada. And so, because you have different roles, different positions, so you'll have to consider both who is the acquirer. So is it, for instance, a AI developers that decides to acquire a producer of AI raw materials? So that will create a different kind of issue and it will have a different rationale. Or is it an AI user, for instance, if that's a case that I've seen in practice, for instance, an AI user that doesn't really have a lot of expertise in AI development, and so decides to acquire through a merger and acquisition transaction a smaller player, kind of like a startup, to integrate the people and to integrate the technology into its technology stack and to expand its technology. So developing technology and developing their service offering through that acquisition process.
Yeah. No, this is great. I wholeheartedly agree. So I used to, before the law, I used to have another career. I was an engineer first, and then I used to work to acquire and invest in technology companies. And so the starting point oftentimes for me is why companies acquire or invest in companies in the first place. And sometimes in that field, you would call it the deal thesis, right? What's the deal thesis for investing or acquiring? We are, for context, in an environment where there is scarcity, and Francis touched on this as well. There's a scarce city of resources, of people, talent, and even the IP. And so you think about, and Francis, you also talked about Cohere locally in Canada. Well, Cohere's a large language model, and they are kind of like, if you could think about the OpenAI, ChatGPT, they are the large language model competitor, but based in Canada. How much does it take to build something like that? Well, it takes evidently a lot, and it's a bit of a barrier to entry. There's probably about 12 large language model providers in the world, give or take, that are in that space. And so if the deal thesis is that you need to own or invest in something of scarcity, well, that is one deal thesis, and there's only so many of them kind of out there. If you're an acquirer, you may not be looking to buy a large language model company, but you might be looking to buy, say, a company that does detecting errors on a manufacturing line. In cases like that, why companies typically buy that is, to Francis's earlier point, productivity. AI could do it better than the previous solutions. And the considerations typically tend to be a build versus buy, the cost and the time involved to kind of build it yourself. And so all of those are kind of the traditional reasons. But what's different about the AI world is that there is a bit of a scarcity. Even when you think about how to build a model, if you were to go talk to a data scientist, they will tell you like half of it is art, half of it is science. And how do you get the art part? Well, you gotta have worked kind of in a field that's similar to what they would be doing. And there's only so many individuals that do that. And so what do I see over the past 12, 18 months? I do see IP buys. I do see talent buys. And I see it across the spectrum of the supply chain, from hardware companies, infrastructure, to kind of software space. And that really depends on kind of where you are as the buyer investor.
And I think we're seeing also, to jump on that, Sam, one interesting thing, and I'd be curious, as I have a bit less years of practice behind me, and I'd be curious to hear you, for instance, if you see a difference with other industries. But one thing that's been interesting in the AI space is the use of partnership and very like strategic investment as well. So sometimes when we think about merger and acquisition, we have in mind the classical case of like a full acquisition, like a complete merger. But we've seen like in this space, and that at a very high level, I'm not saying I've seen that specifically in Canada, but we've seen that with the biggest players, for instance, NVIDIA, but I have particularly in mind Microsoft and the relationship they build with OpenAI. There's also this relationship of not necessarily acquiring fully the company, but building minority positions in certain strategic AI company, and placing different bets with different players. And again, it's really interesting to go see the Competition Bureau's analysis, because they have a very neat graph where they map all the different partnerships that we see from different AI players in Canada, but mostly in the US, where you see where NVIDIA, Meta, Apple, Amazon, and other big players have put their money in those different players. And to touch on an additional point that I think makes this era of investing, from my vantage point, a bit different, is how much the big players are involved. And I think I'm really not the first to make that point. But it's really interesting to see that a lot of investment and a lot of innovation is actually coming from the biggest player that have also the biggest, the biggest capital resources to invest, and how it relates and affects the startup industry. And so maybe that's also a point to you, Camden, that you mentioned that we're working a lot with the startup space. Like, how do you see this affecting the space to have those big players involved? And again, to mention the Competition Bureau's reports, that's something they're also looking at from a competition law perspective.
Yeah, I mean, I guess just to respond, I'm not a technologist, I'm not an expert in AI, so maybe I would respond with a question for you guys. I mean, I agree with what you said, Francis. I mean, when you look at the AI landscape, which is developing very rapidly, it's currently dominated by, really by very, very high productivity U.S. firms are sort of dominant right now, and then China's a factor as well. But it's really kind of been a U.S. Focused phenomenon. And so I'm just curious, and I asked this sort of out of ignorance. I mean, it seems like with AI, I mean, ironically, it's a digital technology, it's a digital application, but it seems like it requires like enormous capital investment, right, and enormous energy inputs. And it does seem like there's really, really high barriers to entry. So I'm just wondering, if we're talking about like large language models specifically, what is the feasibility for like Canadian companies to really become competitive in that industry, or companies from basically from any country that is not the United States or China?
Yeah, a couple of comments from the get-go, and Francis, just to get at your comment, I don't think that's true. For the purposes of AI, in terms of years of experience, you and I are given the state of AI. I think it's hard pressed to find anybody who's an AI lawyer a decade, which is the opportunity for the students in this room, right? You step out of here and you're part of this nascent kind of adventure with us. A couple of comments I want to say to Professor Cameron's comments. We see a lot of big players in this space because there is a cost hurdle. It is a real hurdle for a couple of reasons. One is the compute necessary to serve these AI models is a real cost. There's without question. But there's also what goes in behind the scenes as well. And so if you're going to create a large language model or really any kind of model, what is the one thing that you need? I'm going to ask the question to the two folks in the front room behind Professor Camden. What is the one thing that you need? Give it a guess.
Data.
That's exactly it. And so where are you going to get this data? Well, I mean, you could try to scrape it from the internet. And so that gives rise to some copyright considerations that's heavily litigated right now. But there's also data that's not so accessible. And I can tell you over the past 12 months, when data companies, there's many of them, even companies that license to universities, licensed journals, licensed data sets, licensed content to universities, I can even tell you that. When those content licensors, when those deals come up for renewal, they will say there is now two prices. One for the traditional consumption, if you want to just conduct research as a student. There's a second price if you want to start to train machine learning models. And so the second price starts to be a very significant and steep expense. And so when we start to look at the disparity between financial resources of larger companies, like the traditional big tech, and the local startup companies, I think that will be a bit of a hurdle. And there is a role too for policy and for government to kind of level the playing field a little bit so that Canadian innovation economy isn't disadvantaged. That said, the other kind of response I have to that is how important it is to also and the role of open source. And so I was an engineer I went to the University of Waterloo for engineering in 2000. And I used to be an open source developer, and open source in some ways democratizes this. It levels the playing field a little bit. And so there's a role in AI, not only for open source to lower the barriers, but also at the same time to address some of the AI related risks like transparency, explainability to some degree, not fully, but to some degree. And so we do see that. Like if you ask me to look at the cross section of the startups that I work with, AI companies, what are they using? Well, they're using the Llama models. They're using it because the cost is a little bit lower. They've got a little bit of flexibility in what they do with it. And they're going to have to build a business model kind of around that. Now, to tie it back to kind of this audience, what does that mean? It means then these agreements you enter into with data providers, that's a licensing question. And I know we'll talk a little bit about that, but there's a role for lawyers, new law students to navigate that. And Francis and I are, to be perfectly humble, we're navigating this as we go. We're trying to apply traditional principles of contract in another context. And in it, I got to tell you, it's interesting, it's exciting, but it's also, the battlefield's just being tested. And curious to, Francis, if you see that from your perspective as well. That's certainly the lens that I see at the last 12 months.
What I'm monitoring in particular is all those decisions in the lawsuits in the U.S. And in Canada now about this very question of access to data, right? And a lot of developers, AI developers that created the initial large language model, they had the advantage of working in a world where those practice of knowledge, for all intents and purposes, were unknown. And were unknown by the rights holders, right? And you really see it with the rise of ChatGPT, right? With almost 2 or 3 months after the launch of ChatGPT and the information of how those models were trained, which was not hidden, right? But was not well known and was not publicized. Those lawsuits being launched, right? And those lawsuits and the result of the lawsuit and the evolution of intellectual property law, but also privacy law, right? Because there's also issues of collection of personal information, and we've seen that especially in Europe. How those laws evolve, they will dictate how much freely the data on the internet can be collected and can be used by AI systems. But another point is what we can ask is how much is it an important question in the future, right? How much important is it important for the next startup that's building up this year to replicate what OpenAI has done or replicate what another player has done? I think what's also more interesting is how new companies will develop new AI application and new AI systems based on other data, right? And we're seeing lots of progress, for instance, in robotics, embodied AI systems. Sammy mentioned agentic AI system, and how access to those new data that may be even more complex in accessing them than data that was available on the internet. That's going to be a very interesting question. And just an example, how do you get data on how people move, for instance, right? To teach to a robot, a humanized robot, and there's a lot of companies building up humanized robot. How do you access the data and sufficient data, to train those robots efficiently? It's kind of like it brings to the question of accessing the data, privacy, private information. So data is definitely key and will remain. I agree, fully agree. Will remain a big hurdle and a big source of cost.
So my next question is kind of a two-part question. So imagine, hypothetically, that you're working on the acquisition of an AI-focused company. What are the major due diligence issues that you would want to be aware of? And what are the major purchase agreement issues that you would build into the purchase agreement?
Happy to start with this one. Because I'm talking to law students, you may or may not have taken a corporate M&A class. And so maybe I can step back very quickly in really just 2 sentences. When we're talking about due diligence of a company and buying a company, it's kind of like if you were to buy a car, a used car, for example, what would you do? Well, you would probably take it to the mechanic. You'd probably ask them to pop the hood so you can look at the engine. You probably walk around the car, turn the knobs to make sure everything works the way that you'd expect so that you're getting what you're buying and the value of what you're paying. And so that ultimately is a key part. It's not the only, but it's a key part of what diligence is for, to ensure that the purchaser, and in many cases, you'll be advising the purchaser or the seller when you practice this area of law, get what they had bargained for. And so traditionally, in the old world, if you're just buying a tech company, what are you concerned with? Well, you're concerned with software. This tech company writes software that does what it says they did, that they have the authority to actually write the software, that was owned by them. But in the world of AI, that's changing a little bit. And I never like to use the word new, but it's an application of the existing approach in a new context. And so when you're starting to buy an AI company, you want to start to think about what are the assets there. Is it just the software? Well, there certainly is software, but there's also now the importance of data sets, the data sets that you've used to train these models, the data sets you use to test and improve these models, and of course the models themselves, right? And so to start thinking about the categories of AI-related elements is really, really important. I want to leave some additional comments for Francis, but I'll stop with just these 2 things, and then I'll kind of respond, and we can have a conversation with Francis. But 2 of the most important is the IP assets, which might now start to include models, and the importance of kind of data assets. Those start bubbling up to the top.
What I would add to that is especially if you are acquiring an AI developer, so somebody who has controlled the process of bringing that data, creating the algorithms, developing the model, is how have they set up their AI governance internally? That's something that is very important because you want to assess how mature they are in that regard. So especially if you're working in a space like the European context where there is laws that are coming into force around those issues, but even in Canada, there are growing international standards that will be useful as a benchmark, even though, as Sam, you mentioned at the beginning, ADA and Bill C-27 are no longer with us. So in terms of AI governance, like we're looking at like, have they implemented an AI governance framework that's based on a recognized standards that can be verified through simple question answer, providing certificates, for instance, but also reviewing a bit like we do when we review a company for its privacy compliance. Well, do they have an AI policy, right? For instance, that governs how they use AI systems for their software development, right? And that's tie-ins with the IP issues that Sam mentioned earlier. Because you may know, or you may or may not, in the IP sphere, also AI has created a lot of issue. And one of the issue is that it's still an open question, at least in Canada, whether or not content that is fully generated by an AI system is deserving of IP protection, right? Can you register, for instance, something that you, like a piece of art, let's say that you've generated fully by an AI system? There are some existing jurisprudence in the US that says that no, you need to have sufficient human contribution, human authorship. And so you can see some issues bubbling up if, for instance, the code base of an AI company that you're acquiring has been built based essentially on code generated by AI. That would still be very difficult today because I'm not a programmer, Sam, but from what I hear from my programming friend is that AI is pretty good, but you cannot rely fully on it to draft anything close to a working application. But still, as a concrete example, I was working on a transaction recently where in the due diligence, the company we were wishing to acquire, we were working to acquire, well, they disclosed that 10% of their code was generated through AI systems. And then they explained to us their process to vet that code and to ensure that that code, well, first of all, they own it, but also that it was working properly, right? And so that's an example, but I'm expecting to see more examples as those, and let's say the proportion of code generated by AI systems to increase in the coming years. So you can see the different issues, right? The AI governance issue ties in with the IP issues, but also the privacy issue, right? Especially in Canada, we have different privacy laws in different provinces. In Quebec, for instance, we've updated the law recently to add additional provision that apply to AI systems as well. So for instance, now we have a provisions around automated decision-making systems. And so I ask those types of questions. Are you using AI, for instance, to make decisions about employment, right? So that would be a decision that involves personal information, but also the rights of an individual. So there are different requirements in that that can apply for both from employment law, but also from privacy law. So all this ties in for me, from my perspective, in question of AI governance and how they have set up their AI governance. Admittedly, from what I've seen right now, AI governance is still a work in progress in many businesses. I'm wondering, Sam, if that's also something that you've seen.
Yeah, very, very, very much so. I think if you ask most of the clients, even the very sophisticated ones, where are you with AI governance? They would probably tell you we're working on it. But I will also tell you conversely that in the context of trying to buy a company in M&A, if you ask the question, where are you with AI governance? And the answer is they don't have one, then you can probably, and the outcome will probably be along the lines that something isn't fully kind of kosher. And so what I mean by that is the classic example is of the AI companies, true AI companies, so AI companies that are building real AI solutions, not just called .ai. If they have a good governance program, it's usually the case that there's something about the data that they're doing with the data that they didn't have the full authority to do with the data. It's a bit of a Wild West these days, and it always frightens me when I go visit clients and I talk to their data science team, and I ask them questions like, "This is very interesting. Where are you getting the data?" And then when I hear the answers, it's very quickly followed up with, "We should do something about that." And so it's a real question, and I think that's a real part of diligence. And so one of the core principles of privacy, and for those of you who've taken the privacy class, and I know Francis and I deal with this on a regular basis, there's a there's a principle where in privacy we're following the data. And following the data will lead you to the data provenance, data sources, and somewhere along the chain, it's always less than perfect. And so that's the thread I often pull on when I do diligence in AI companies. And so it's the equivalent of in the car situation, buying a used car, there's probably something that's not fully what you thought it was. And the reality is that because governance isn't perfect and all of this is evolving, it's about helping clients understand in this state of perfection, what is the scope of risk that they're willing to accept and what steps you can take to mitigate the risk. It's not a well-settled area. And that is why I think, Francis, you probably agree. That's why we're kind of drawn to this, right? We get to figure it out. We get to deal with the ambiguity, but also provide practical guidance that at least mitigates the risk for our clients on both sides of these transactions.
And it's been interesting to see and to go to Ken and to go to your second part of your question about purchase agreements. It's been interesting to see purchase agreements evolve, right? And again, also for those in the room that may not be familiar with the M&A process, so once you've done due diligence and sometimes even in parallel, parties will draft, usually from precedent, so we'll draft a purchase agreement, right? That can be an asset purchase agreement if you're just buying assets, but also a share purchase agreement if you're buying the company outright through its shares. And the purchase agreement is really a key document in most transaction. And one of the key portion of that document is what we call the representation and warranties, right? And this is where the famous sharing of risk or apportionment of risks will occur, right? And this is where parties will decide and negotiate about, like, okay, how do we negotiate around and how do we negotiate around uncertainties about certain risks, right? And parties will, for instance, give representation. Well, the sellers will give representation and warranties. And the buyer will obviously try to have as much representation and warranty as possible. The same thing as Sam, to take your car example, right? You want the most extended warranty. You want the warranty on every single part of the vehicle. Buyer, they want warranties that apply to every part of the company, but sellers want more limited warranties, right? And what we've seen, for instance, in AI systems, like it's precisely reps and warranties about models, right? How have you built your models? Can you disclose the data sets, the source and the origins of your data? I would say, like, to build on what you said, Sam, that's a key question to have an answer to. And if the question to that question is we don't know or we cannot tell you, it's a very high risk for businesses, for a business to acquire a business that cannot answer those questions. But you'll also have different reps and warranties. For instance, well, we've built that data set, for instance, that we know is made of personal information. Well, we represent that we've built that data set in compliance with privacy laws, right? And usually parties will negotiate different limitation, right? You'll have materiality carve-outs, you'll have delays and terms to that warranties. For instance, saying, well, in the last 3 years, we've always complied and we've built our data set to the best standards, right? But it's limited to a certain period of times. And it's an area where the market is pretty much evolving, right? I couldn't say, like, well, this is a market AI rep and warranty, right? It's being built as we speak. And one challenge is that because the technology is evolving so fast, we're evolving and changing the language along and based on the deal and based on the context. So it's going to be interesting to see when you start practicing if that, those standard reps and warranties, this standard purchase agreement language will have stabilized to a more, to a certain set of standard AI clauses.
Yeah. And what Francis has shared really is the leading edge of what we're seeing. And so if you are embarking on kind of a summer internship or articles, and you're taking notes here, I think that is something that I think would impress some of your principals. But also, as you're thinking about kind of papers you might be writing, this is actually a very interesting topic to explore, like reps and warranties, maybe different kind of contexts. There is no new norms. And so you're very much thinking about it, much in the same way Francis and I are kind of thinking about this in practice.
One thing I might add, just to follow up a point that Sam made, and I'm speaking again not as an expert in AI, but as somebody who used to be a practicing lawyer, in M&A and venture capital to a certain extent, is your job as a business lawyer, or part of your job as a business lawyer, is to advise your clients as to risk and to explain the legal risks that your clients' business activities may entail. But your job is not necessarily to tell your clients what they can and cannot do, right? So you need to make sure that your clients are aware of risk. You need to make sure that your clients understand risk. You need to make sure that they understand the potential legal consequences of different business choices. But it's actually not your job to tell your client, like, no, you can't do that. You can't do this. You can't do that, right? Like, nobody likes that kind of lawyer. You're advising your client as to risk, and hopefully, maybe providing them with, creative alternatives or solutions to mitigating that risk. But, especially in the startup world, like, entrepreneurs who are starting a company, they're very comfortable with risk, right? They've already taken an enormous business risk, an enormous, life risk, frankly, by starting a company. And a lot of times, they'll be involved in business activities that kind of, sort of skirt the edge of regulations, maybe doing things that are not completely by the books. And they're often very comfortable with that. And you sort of just need to explain to them what the potential consequences are, but they're the ones at the end of the day who make the business decision about whether to engage in a particular acquisition, or whether to, I don't know, use data that may have come from a questionable source, right? A lot of these startup companies are very comfortable with risk, and obviously, you need to be ethical and sort of tell your clients what they should and should not be doing from an ethical standpoint. But when it comes to business decisions, it's really your job is to inform them and to advise them and let them make the ultimate business choice. Okay, so maybe getting away from M&A a little bit and sort of switching gears to commercial transactions. If you're representing an AI company, what are the sort of major types of commercial contracts that they enter into? Like, what are their customer contracts? What are their supplier contracts? That kind of thing.
Do you? I can start
Yeah,
on perspective. I'd say that my perspective is a bit more from the perspective of the client of AI companies. So from what I've seen in this space, and maybe Sam, I'll let you speak more about the AI companies themselves, but what I've seen in my practice is a lot of services being provided around AI systems to improve, as I said, and I mentioned the example, to improve productivity, to bring new solutions, to take a business process and to improve it. And sometimes it can be a very specific business process. I've given the example of the company that wants to improve how it does a food review on its line. So that was an example. But more generally, I think to go back to the AI companies themselves, well, there's going to be data acquisition agreements when there are some. And then, as we discussed in the space, some things have been just taking data that were available publicly, and so without any agreements with the data provider. And that's what we're seeing litigated, right? And just in the space, if you see OpenAI, for instance, they've entered into multiple agreements with, for instance, news providers in the US to have access to a constant feed of data, right? And so data will be absolutely critical. I'd say one of the other aspects will be infrastructure. And that's why you see a lot of important agreements between AI developers, so the ones that have the knowledge on how to build the algorithms, but don't necessarily have the computing resources to do so. That's why they'll enter into different types of deals. And the deal, for instance, between Microsoft and OpenAI is a good example. They'll enter into deals with hyperscaler, right, to have access to those compute. So companies like Microsoft that provides Azure, that you have Amazon also, and you have different types of companies that will provide those resources. And then also, well, and this is more, it's not necessarily specific to AI, but you'll have also a lot of, let's say, staff augmentation service agreement, right? So company may need to have a specific expertise that they don't necessarily have in-house, and they will, contract with a service provider who can be, an individuals or very niche company that will, bring for a limited period of time some expertise in-house to help them build their solution.
Yeah, that's right. And just rounding that off from the other side, and so there's the customer, and then there's also the company that develops the AI solution to sell to the customer. Just let me say that what I love about this question is that it's again the relevance to everyone here. That at some point in your career, you can be negotiating, drafting a contract of some sort wherever you are, and most certainly if you decide to kind of go the in-house kind of route. For AI companies, the number one contract you're going to have, or you would see when you're advising clients on either side, is actually that customer contract. For most AI companies, most of the AI solutions are no longer the installed software that you install on, I guess, this DVD, but most software is actually available over the cloud, and you'd access it on your web browser, like you do to Gmail or Google Documents. And so for a lot of AI companies, that's how they sell. They sell through a software that's hosted by them. And so what's really, really interesting about this is if you think back at your contracts class and your intellectual property class, what's inside these contracts? Well, these contracts talk about really the bargain between two companies. What am I getting back? What assurances are you providing? And in the world of AI, it starts to be interesting. Things like what you can and can't do. Customers are really concerned about what AI companies can and can't do with their data. What restrictions are put in place? Can they use it to further improve an AI model? I mean, you hear and read about these things, but they're real issues. And on the flip side, when you're advising AI companies, a lot of times machine learning AI solutions, they do improve. That's the learning aspect, not just during training, but during the performance of the actual AI solution. It does learn. And so to thread that needle isn't always easy. On the one hand, customers are really concerned about what happens to their data. On the other hand is the dueling tension that AI companies, they really want to improve the product with each engagement. Really no different than if you think about a contractor or a consultant, that after each engagement, they kind of improve in their ability to perform the services. And so those tend to be really thorny issues, like when you're out there. And if you are doing a summer or an internship or articling position at a firm, I would look for opportunities to see that tension out there. There are other issues with respect to data. Customers are starting to be very distinguishing now and starting to ask AI companies, how did you build that thing? Where did you get your data from? How can you be sure that when you're using an AI solution, for example, in the employment context, that it is free from bias? And every AI company will tell you it's impossible to be free from bias. But here's the steps I take to mitigate the risk, to improve our solution. And a lot of the conversations you have are going to be about the things that you're going to have to find a path forward, and that there is no standard for this. Even what constitutes acceptable bias is not actually that easy. What's responsible and safe development of AI companies? I mean, there's the Responsible AI Institute, but a lot of these things are really just coming to be. And so that really requires a degree of creativity to navigate them. And so when I speak about this topic on kind of AI and commercial contracting, often what I say, it's the application of what you know, but in the context that you're going to really have no map, and you're going to have to figure it out and kind of blaze their own path. They're evolving norms, Francis and I see it. But that's what it is at the end of the day. It's evolving norms that we're starting to see, but certainly far from an accepted, tried and true kind of path.
So maybe as a final question, from a macro standpoint, what are the major regulatory issues facing AI companies in Canada and beyond?
That's a big question, Sam, right? That's the
it is.
We see, right?
I'm happy to start, or you can start now.
No, please start there.
Yeah. So when we talk about regulation, I think about it into two baskets. There's AI specific regulation, And then there's existing laws. And so we had Bill C-27 Part 3, which is the proposed AI and Data Act that's died now on order paper with the Parliament being prorogued. That would have been an example of a AI-specific regulation targeting AI technology. But even absent that, sometimes I hear from students, oh, now we actually don't have regulation governing AI, to which I often respond, well, let's not forget there are existing laws in place. There's data privacy, there's copyright. And if you were to ask me to pick one that is squarely in the spotlight, I would probably say copyright, if not privacy, is right up there. And so here's the challenge. If you look at copyright laws in Canada, how do you build an AI model? You need to take data sets. How do you build a large language model? Well, the most obvious source of data is the internet. But the internet is full of content that is copyrighted. It's protected by copyright. And because it's protected by copyright, there's a tension between the rights of creators and authors who want the opportunity to monetize and benefit, but they're at odds with companies that use this data to build AI solutions. And so when you look at some of these, some of the litigation in Canada and the US, a lot in the US, that is the fight. And so Canadian copyright laws are similar to the US, but they do vary a little bit. And so the defense to using data sets scraped from the internet to train is, in the US, it's fair use. In Canada, it's fair dealing. Fair dealing in Canada is a little bit narrow as compared to fair use in the US. And there's less exemptions under Canadian law actually than there are in the EU. And so this is a major regulatory issue because a lot of the innovative AI companies need data sets in order to be able to build their solutions. And there's a big policy question that's at play here. There was a copyright consultation that ISET had put out about a year ago on how copyright laws should be. And one of the questions is, should there be a broader exception for text and data mining so that AI companies could benefit from training? That's going to be a tough slog to kind of resolve. But the reason this is important, and the reason it's important for law students and even budding lawyers to pay attention to this issue, is not only are you going to need to advise clients on navigating this, but also there's a big policy issue as well. If Canadian copyright laws are more restrictive than copyright laws in other regimes, what's going to happen to the innovation economy? And Francis talked about, he talked about productivity. Some of the best and brightest companies in Canada, AI companies, they don't have to have their technical folks in Canada. They have a choice. These are well-financed companies. They could have all of the R&D now moved over to a more friendly jurisdiction for AI training, and then have basically a sales center in Canada, right? And is that what we want? And so I think we're going to have to really be thoughtful. And I think all of us will have a role in shaping policy, of course, but also advising our clients that kind of navigate this. I'll finish with one thought because there are other considerations as well beyond just copyright, and I'll pass it over to Francis. But it's not just for companies who develop and design AI solutions. It's also one for the users as well. Just as you're a user of an AI solution, you don't want to wear the risk if there's copyright infringement concerns. And so this will manifest in all of the other things we talked about. In contract, you're going to look for assurances. When you're evaluating solutions, you're going to start asking questions about where the data is. But I think that's a very important and key regulatory consideration, and one that certainly we're following very closely.
Yeah, I think the last point is very interesting, and it's sort of when we discussed about purchase agreement, we were discussing about risk and who should bear the risk, and when we're talking about regulation, we're talking about a similar issue, but at a macro level. And to talk a bit, because Sam, I think you described really well the context within Canada, how it has evolved, and now we used to have the Artificial Intelligence and Data Act. Now we don't have it, but it's a very good point that there are still a lot of existing laws. And if I can add maybe a few, product safety rules as AI becomes more embodied would also become an issue. And I've mentioned it a couple of times, but competition law issues as well. But if we take a step back from Canada as well, from a, let's say, for a student of regulations, that's a very fascinating moment, right? Because you're seeing right now, in real time, different jurisdictions trying different methods to regulate the same thing, right? And what's interesting is that in a lot of cases, and I don't want to say that's the first, I think this is the dangerous thing to say, but I think it's relatively rare in law that we use a prospective approach such as this in regulation, right? A lot of the technology that the EU AI Act or the Artificial Intelligence and Data Act sought to regulate are technology that are existing, but also technology that are coming and that we don't exactly know the shape of. And that already occur, if I can say, because those laws were being drafted. And in the middle of their drafting, the old generative AI movement and technology appeared on the scene, and it forced regulators to redraft those laws quite rapidly. And so if we talk about the different emerging approaches, well, Europe, as an example, I think taking a lot of cues from the General Data Protection Regulation, so the famous GDPR, they've taken that approach of creating a law of general application at the EU level that aims to essentially govern every aspect of AI, right? And they have consideration, they have link in that EU AI Act to the GDPR, so privacy consideration, but they also have links to EU IP laws, to product safety laws. So it's a general regulation that imposes various obligations of good AI governance when an AI player puts an AI system on the market or uses an AI system. And it includes also, if you don't know, some provision that have already entered into force a few days ago about prohibition of certain AI systems, for instance, social scoring. So this is the EU approach. In the US, it's a mix. We can say we have at the federal level a lot of evolution right now. So with the change in the administration, the Biden administration had put in place an executive order that including a lot of measures that order the federal government to develop good AI governance standards, but also imposed on AI developers certain obligation of disclosing models that were posing severe risks, right? Now, with the coming of the Trump administration, that executive order has been rescinded. And we now have new executive order that essentially the word seems to be innovation, 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 right? The way they now see artificial intelligence system, it's a major geopolitical issue for them, so at the federal level. But what's interesting in the United States also is that we are seeing a lot of different states adopting their own AI laws to different to address different issues. So we have some in California, Colorado, Utah, and other states are studying this. What's interesting is that Canada, I think the approach we're trying to get was a bit closer to the EU. So the Artificial Intelligence and Data Act was also a law of general application that seek to give a general framework for AI system, although it was a bit more constrained, a bit more limited. But now we kind of at the federal level, we don't have this law anymore, and it's hard to tell from our perspective whether or not, when we're coming elections, whether or not we will have in the near future another bill that seeks to address AI. And I don't know if you've seen this. I don't know if there has been more activity in Ontario or in British Columbia, but at least in Quebec, not a lot of activity in terms of legislations for now at a provincial level in Quebec. So it's a transition period. I'm really curious to see where it goes, but I think at least in the near future, we'll see a lot of activities at the state level in the US, and we'll see how the coming into force of the provisions of the EU AI Act affect the EU market, right? And we'll see. I think Canada, I would say that Canada is, I think, in a good position to learn from other jurisdictions what occurs. I think we have good existing law, and the question will be, how do we apply those laws to AI? I think we can take the occasion to learn lessons from both the EU and the US to see what kind of like more general law about AI we need.
All right. Well, thank you so much. We've got 5-10 minutes left. So why don't we turn it over to audience questions at that point, including any questions online if there are any. Any questions in the classroom?
All right, so we have a question from one of our online attendees. Talking about data scarcity and barriers to entry, it occurs to me that the concept of essential service might be useful. Should certain providers be required to grant access so that competition is not closed off?
I think forcing somebody to do something is a tough proposition, especially where other jurisdictions might not have a comparable kind of requirement. But I think there are things that we can look to, though, when we look at kind of the problem of data scarcity. And what I often look to is, even under our copyright laws, like, it's a bit of a balance. It's not just for creators. Copyright is also for the good of society. And so for that, we look to provisions, and in some cases, exceptions to the copyright laws for where it could be beneficial, and things like satire, things like research purposes for academic research. And so there are some exceptions that exist. And I think that is an approach that might be able to kind of balance some of the concerns for some of the creators, but also for the benefit of society. And I see that may be a path that legislators can explore to be able to kind of solve and get at that challenge. The other is just from a policy perspective, right? I think as part of the federal government's kind of $2 billion compute, I think one of the questions they're looking into is the question of data too, and whether the government should be looking at incentivizing and really supporting more of an open government, open data kind of initiatives. Now, these are aspirational. There's always pros and cons to how effective these initiatives are, but I think it's one step in the right direction.
I think it's going to depend a lot on the type of data also. There are different issues when you're talking about personal information versus IP protected information, so information protected by copyright. I don't think like a blanket, and I think it's hard to answer the question from a blanket perspective, like all types of data. What's there? But I think there's a different solution. It can be, let's say, from a legal and technical perspective, that depending on the type of data can be used to increase the access to data. So I don't think we're going to be in a world where there's going to be like free for all to any types of data, but there might be solutions. So from a technical perspective, you can, for instance, think about different techniques of anonymization or de-identification of data. So you might have different data custodians that have access to very precious and important data sets that decides that around certain legal constraint that decide to make available data sets that have been anonymized, right? So we remove the personally identifiable information from the data set, for instance. Another point is that if you're interested in that type of question, what you might want to look into, for instance, is the idea of data trust, right? So creating a trust, so a body that has for main mission to be a kind of steward of data. And there's been some example of this in the European Union, I think in the UK, for instance. So that's an area you might be interested in looking into. And I think the type of data, I think, is important, but I think one of the important data point will be, what's the use also, right? And to go back to the question about, fair dealing, fair use. Well, as part of this analysis, one of the criteria is, what's the use for? For instance, is it a type of use that will, compete or aim to replace for instance, like the artist that has created the art or similar points. So that might make it more difficult for someone to rely on that sort of copyright exception. But that's very much a live issue. Also, and I'll go back again to the Competition Bureau's report because it's very interesting, and I encourage that read. That's an issue, right? And there can be an issue from an antitrust competition law perspective, right? And so it's pretty much not a settled question. And I would say, though, I would be surprised if we would get to the world where it's fully open for any type of data. I think it's going to be a world where there's going to be a lot of exceptions, and is going to be different legal regimes for different types of uses and different types of data. So a great area to work in for most probably in the next years.
Any other questions in the class or online? No. Okay. We are almost at the end of our allotted time, so I guess we can go ahead and end it there. So let's have a round of applause for our two panelists. Thank you so much. That was a really insightful and interesting discussion, and I really appreciate the two of you taking the time. So thank you very much.